Good afternoon, everyone, and welcome back to the speakers series at the College of Law at the University of Saskatchewan. My name is Brent Cotter. I'm a professor at the school and the chair of the speakers committee for the 21-22 academic year at the university and the law school. Today we have a special treat, the Silas E. Halyk QC Lecture in Advocacy, to be delivered by this year's visiting scholar in advocacy, Donald Worme QC. He will be introduced momentarily by Elise Brass, and I'll turn it over to her in just a moment. I'm going to say a word or two about the Halyk Lecture in Advocacy, but I want to first call upon Dean Martin Phillipson to bring greetings to you all in the new year and a continuing law school year. And then Martin will send it back to me to get the proceedings underway. Dean Phillipson.
Thank you, Brent. I appreciate it. Good afternoon, everyone. As we begin, I'd like to acknowledge that we're on Treaty 6 territory and the traditional homeland of the Métis, and by paying our respects to the First Nations and Métis ancestors of this place, we renew our relationship with one another. I just want to say a very brief word before the introductions to thank you all for attending. The college, has been in person, not in person over the last 2 years, and we continue to go back and forth. Hopefully, we will be back in person on February the 7th, but I want to thank all of you for attending, and I want to thank our speakers, all of our speakers, including Dawn today, for being willing to present in a virtual format. But most importantly, I just wanted to say a word of thanks to Cy Halyk for his continuing support of this lecture. We're very fortunate in the bar in this province to have some outstanding advocates. Dawn is just a long line of people that Cy has asked to present the Halyk Lecture on Advocacy, and we're delighted to have Dawn with us today. And Cy is with us today, but I just wanted to say personally how grateful we are to Cy for his support of a very important area in terms of working on advocacy in the province and allowing our students to spend some time and for us to listen to some of the great advocates that we have in this province. So again, thanks to Cy. Thank you again to all of you for attending. The attendances have been very good, and I really want to thank you and encourage you to attend more of these lectures. We do have some very interesting speakers this semester, and I'm going to hand it back over to Brent, and thank you all for your attendance. Have a good day.
Thank you, Martin. Once again, welcome. As many of you know, Cy Halyk QC is one of Saskatchewan's most distinguished advocates. Some years ago, probably close to 15 now, Cy, Mr. Halyk approached the law school with a vision that could maybe strengthen advocacy at the law school and would benefit law students and ultimately lawyers, young lawyers in particular, but young lawyers more generally. And as the central part of that inspiration, he proposed and funded the establishment of the Halyk Lecture Series in Advocacy, which has made it possible for us to bring distinguished advocates both in Saskatchewan and across the country to come and spend a bit of time at the law school. This year, somewhat awkwardly challenged by COVID and the circumstances of doing much of this virtually, but nevertheless effectively. And we are, the list of Halyk lectures is really a distinguished list of advocates in this province and country. And that list is being significantly added to today by the opportunity for us to hear from this year's Halyk lecturer, Don Worme. I won't say more about that other than to just describe the sequence of how we would intend to proceed this afternoon. After these short remarks by me, I'm going to turn things over to Elise Brass to introduce Mr. Worme. Following that, Don will deliver his lecture, and Professor Jamie Lavalley of the law school will moderate the discussion, field any questions that people may have, watch the chat to identify questions and pose those to Mr. Worme. And at the end of those proceedings, I'll provide a short conclusion and thanks. So at this stage, if I may, let me turn the proceedings over to Elise Brass to introduce Mr. Worme. Elise.
Thank you. Mr. Donald Worme, QC IPC, is a founding member of the Indigenous Bar Association of Canada, a national advocacy group comprised of Aboriginal lawyers, and as a Cree lawyer from the Kwakatoos First Nation, Treaty 4 Saskatchewan, Mr. Worme is one of the leading advocates in the province for criminal law and treaty litigation and has been a vocal member of the Saskatchewan Human Rights Tribunal since 2001. Mr. Worme has been involved in developing and reviewing public policies under the scope of Aboriginal and treaty rights. He was engaged in the studies and analysis for the National Indian Tax Advisory Board and has provided both research and commentary for the Royal Commission on Aboriginal Peoples. Mr. Worme served as Commission Counsel during the Ipperwash Judicial Inquiry. He also acted as lead counsel to the family of Neil Stonechild in the Judicial Inquiry into the Saskatoon Police Service's involvement with the teens freezing death in Saskatchewan. Mr. Worme graduated from the University of Saskatchewan College of Law in 1985, and he received his Queen's Counsel appointment in 2002, as well as his Indigenous Peoples Council designation in 2006. He's been a profound inspiration to myself long before I was accepted into law school. Please join me in welcoming Mr. Don Worme.
Let's see, I guess I could unmute myself here. Right, well, thank you very much, Elise. That is the second best introduction I ever got. The best introduction I ever got was actually a couple of months back when the person who was supposed to introduce me didn't show up, so I got to introduce myself. Anyhow, thank you for that. Thank you for those very kind words. I want to start out by acknowledging, of course, you, Elise, for those kind words, as well as Brent Cotter, QC. Senator Brent Cotter, this man is extremely busy. As you know, he has a very long and storied reputation and career as well. He's been a teacher. He is a commissioner in this province, and more recently, he has been a senator. And as you know, senators are extremely busy. But nonetheless, he managed to track me down to provide me with this invitation. And after a bit of telephone tag, we actually did get a chance to connect, and he did talk me into it. So Brent, I hope I live up to to what is expected of me. I did have a look at the previous speakers on this, and I can tell you that it is totally intimidating. To follow the likes of, for example, Christine Glazer, QC, Judge Jerry Morin, who spoke about the legal system in Saskatchewan from his perspective as a lawyer, and then subsequently as a judge. Professor Charisma, is it Mathen, who spoke last year on strategic litigation, and one of the other ones, notable speakers, of course, was the former Chief Justice of the Ontario Supreme Court, Justice Warren Winkler. So to speak in the footsteps of these, as well as many of the other individuals that have taken on this task in the last 15 years is pretty remarkable, and it is very intimidating for me. And I got to say, what an absolute honor it is. Let me just comment on the picture that was shown on the University of Saskatchewan's invitation. That thank you, first of all, for using that picture. That was taken some 12 years ago. It was before it was photoshopped for an actual better picture. And two reasons for commenting on that. Number one, I look very young in that, so thank you so much for that. And number two, it looks like my mullet is back in fashion. I heard the mullet is making a resurgence anyway. So a lot of you COVID-19 insulators you'll find yourself with a similar hairdo at some point soon. So as I was thinking about what to say in providing a lecture on the point of advocacy, I really looked far and wide for something that might be useful. And at the end of the day, I'm afraid that there is nothing that I have except for my own experience. And I want to perhaps talk about advocacy from that perspective. But before I do, a few words about my friend, and I can tell you a mentor to me for a very long time, Mr. Silas Halyk, QC. When I was in law school, in 1982, 83, 84, it was pretty remarkable. I mean, Cy Halyk was already a legend then. He was a criminal lawyer extraordinaire. He had a prestigious practice that stretched from one coast to the other. And when people, particularly people with means, when they got in trouble, they said, better call Cy. It wasn't better call Saul, it was better call Cy. And as we know, he has had a very distinguished practice and continues to mentor very many of us. We know that he received his Bachelor of Laws from the University of Saskatchewan in 1961, and subsequently a Master's in Law in maybe that was 1966, if I got that right, Cy, from the University of Michigan. In any event, he has been not only a distinguished professor and lecturer at the University of Saskatchewan, but a mentor to a very great many of us, and he continues to be. I should also mention that I was classmates with Cy's daughter, Judy, who was herself a very fine lawyer. She toiled in the criminal prosecution unit here in the city of Saskatoon, and retired, as I understand it, as one of the senior prosecutors in the province. I also want to pay special acknowledgement to Cy's partner, the indomitable Kathy Knox QC, whose seminal work in the Mount Cashel orphanage and thereafter, in my estimation, had triggered a lot of the advocacy work that dealt with institutional abuse of children in institutions, including the Indian residential school system, which I will talk about in a bit. But I got to know of Cy's work dealing with judicial inquiries. I know that he was instrumental in the Milgard inquiry, and I got to meet both he and Kathy at the Stonechild inquiry, where they represented the Federation of Sovereign Indigenous Nations, and whose involvement assured that that was, again, in my respectful submission, a successful judicial inquiry, which resulted in numerous recommendations which have brought systemic change to not just this city, but this province, excuse me. So on this advocacy lecture, I want to talk about advocacy generally, but more specifically, social justice advocacy. And to talk about how lawyers can best advocate for clients who are discriminated against by the civil or the criminal justice system. What tools are available? What tools are available to examine the judicial system, to examine judicial inequities or inequities generally, to be able to use the law as an instrument for change and as a tool to promote change for those communities that are most in need, those marginalized and racialized communities. Marginalized communities, of course, include poverty-stricken individuals, whose numbers, in fact, are rising, particularly in these pandemic times and in these economic uncertain times. We know that there are many that are negatively affected, and the social issues that are impacting upon those populations continue to rise. There are housing inequities, there are access to education issues, there are social assistance issues for those that are marginalized by poverty within our community. We have ill people and elderly people. We have those who may have received tainted blood or have consumed contaminated water. A large population of marginalized individuals includes prisoners in this country. One of the first cases I took on was the right to vote case with our Sugar versus the Attorney General of Canada, which was a right to vote case. I worked on that file together with Chip O'Connor, who most recently was awarded a prestigious award for his work in the prison system. we also have those that are marginalized in their attempt to get medical treatment. And as we find this pandemic continuing now in its second year to crush not just economies, but societies, I think that we will find, and we can anticipate, that there will be more of these issues about access to healthcare. What will we do about the debate between the vaccinated and the unvaccinated as that continues to move forward? These are issues that we need to continue to keep in mind. But there are no end to marginalized people. Racialized communities, well, I mean, that's pretty obvious, but in my experience, it meant Indigenous people and Indigenous communities. And in my experience as well, social justice is not limited to the courtroom, and it's not limited to trial situations, even though courtrooms or court appearances might be part of that work. But in understanding contemporary advocacy and contemporary issues facing Indigenous people in this country, it is essential to look at our history. And I don't think we need to go back to first contact in order to do so, because the first 200 years thereabouts of contact between Indigenous and non-Indigenous people was relatively quiet. But as immigration continued to fill our traditional territories across Turtle Island, things began to change. And I think what we need to understand is that there has been, since that time, an explicit legislative imposition of oppression on Indigenous people since at least 1867 and the passage of the first racist Indian Act. The Indian Act was first passed in 1867, and that particular piece of legislation has permitted, and then some would suggest encouraged, not just human rights violations, but social and cultural destruction within Indigenous communities right across the country. And I think that that oppression is borne out by the social issues that Indigenous people face today. And we can see that on our cities and on the streets of our cities right across the country, that we see marginalized Indigenous people suffering those kinds of indignities, which have a direct linkage to that legislative oppression. So contemporary manifestations of social inequities are grounded firmly in the imposition of those laws and legal systems over Indigenous laws and legal systems. The Indian Act reflected that colonial view. For example, in the 1876 version of the Indian Act, the definition of person in section 3 sub 12 was someone who was not an Indian. You could be a person as long as you weren't an Indian. The Indian Act controls everything from personhood, that is the status of who is or who is not an Indian. My mother was denied Indian status because, and other Indigenous women were denied Indigenous status because they married out. Or Indigenous men might have been enfranchised because they got a professional degree or joined the army. And non-Indigenous females were given status when they married in. Well, that was corrected in 1985, but the Indian Act continues to rule Indigenous people from the cradle to the grave. The Indian Act interrupted commerce. They denied, in the prairies, they denied benefits for farming. The peasant farm policies that were implemented under the guise of the Indian Act were done so to prohibit mechanized farming operations for Indians because they were too damn good. And the non-Indigenous farming neighbors could not compete with them. So these policies were brought in. On the coasts, fisheries were disrupted. On the East Coast and West Coast, we know that our Indigenous brothers and sisters had their traditional livelihoods completely undermined. We know of the lobster wars on the East Coast from last year, that kind of oppression still continues to exist. In terms of movements of Indigenous people, we know that the Indian Act imposed a totally illegal pass system for more than 2 decades to control movement of Indigenous people. The restrictions of COVID and the mandates that we are under COVID are nothing compared to what Indigenous people have had to tolerate for over 20 years. And until 1952, it was illegal for a lawyer to accept a retainer to pursue an Indian claim. So no wonder we got no remedy in the courts. And not until 1962 did Indigenous people get an unfettered right to vote in this country. So that gives you zero political power, because politicians typically will not speak to people who don't vote, and they don't want to talk to people who can't vote. So this is the context of oppression that Indigenous people face in this country. And it's important to understand that none of this is based upon the treaties that were negotiated in good faith and that were executed between nations. Because nations make treaties, treaties don't make nations. There are over 50 plus treaties right across Turtle Island, including 11 numbered treaties that cover most of Ontario, Manitoba, Saskatchewan, Alberta. There are no treaties in British Columbia. Parts of British Columbia are covered, I should say. But for the most part, there are no treaties in British Columbia. In that province, the Indigenous people in that province continue to operate under their Aboriginal title. But there is a reckoning that will have to come with that, and soon. The treaties permitted peaceful settlement right across this country. It allowed immigrants to come to Turtle Island, to establish families, to build their lives in peace and to thrive. It allows the Torrens system to guarantee title in this province, as well as in Alberta and Manitoba. That's what the treaties do. The Aboriginal rights, and those rights that were maintained by Indigenous people, together with treaty rights, were constitutionalized in Section 35 of the Constitution Act in 1982. And out of that comes much courtroom advocacy. We have hunting and fishing litigation across the province. Here in Saskatchewan, again, the province is curtailing and continues to curtail the treaty rights to hunt, fish, and gather of Indigenous people. They continue to implement laws such as the recent trespass law, which hampers and continues to hamper Indigenous people without consultation. We have criminal law litigation right across the board. In our attempt to give life to the promise of Gladue and IP Lee in Section 718.2 subsection E. You have civil law advocacy in terms of the mass torts that have occurred across the country, and particularly the mass torts against the churches and the government who ran the residential schools that ultimately resulted in the Indian Residential School Settlement Agreement. You have litigation where resources law and Indigenous rights meet. You have land claims, specific and comprehensive claims, most of which go through the the Specific Claims Tribunal, but there's also that litigation occurring in the courts, such as the recent Robinson-Huron treaty annuity case that I was involved in Northern Ontario. I had the good fortune to work with the illustrious firm of Nawagabo Corbier, and among our team members was the late Joe Arve QC. But that was a multi-billion-dollar claim, which is currently still in negotiations, which really seeks a piece of the pie, a share of the resources wealth on the North Shore of Lake Huron pursuant to the Robinson-Huron treaties, which specifically contained a clause that the wealth of that territory would be shared with the Indigenous people once that could be done. And that annuity was in fact raised once, about 20 years, somewhere in about 1957 or 1857, pardon me, and it has remained the same since then. So that kind of advocacy and that kind of litigation involves historical examinations of treaties, looking at what was in the heads of the treaty makers at the time, what was in the heads of the parties at the time they entered these agreements, and it really focuses primarily on two sets of evidence, and that is the written record, which for too long has been preferred and given greater credibility by the courts over the oral tradition, which Indigenous people have brought have brought into the courtroom setting and continue to make inroads. And in my submission, the oral tradition and performative aspects of our ways of telling continues to gain traction within the courts. And I expect that there will continue to be a focus on that as particularly the students study this and become more familiar with their own histories and your own stories of your own communities. But there are other tools that are available to Indigenous people, to racialized communities, to achieve social justice. And one of the major ones is the Judicial Inquiry, also known as the Commission of Inquiry. Typically, there is a mandate that prescribes the parameters of the investigation. What is it that's going to be looked at? What are you going to examine? It sets out the limitations of the query. And the genesis of inquiries in Canadian law, in common law, which we received from the United Kingdom, have really kind of morphed into a curiously Canadian creature with a specialized investigative and informative or public informative mandate ever since the 1867 Canada Public Inquiries Act. And there are really two kinds or two flavors of public inquiries, as one might say. There are federal inquiries, that is inquiries like the Prison for Women inquiry or the Air India inquiry. And then there are provincial inquiries like the Tainted Water in North Battleford or the Stonechild inquiry in Saskatoon. And those inquiries are, of course, determined by the nature of the undertaking being reviewed. Is it a Section 92 jurisdictional area, as the Tainted Water in North Battleford was, or is it something in the nature of interprovincial travel, as Air India? And that, of course, determines. But public inquiries differ from courts in very many ways. In the courtroom, you have a very tightly controlled setting, you have a very tightly controlled process, and you're limited in terms of what evidence comes before the court, and you have procedural rules that are intended to reflect this and to control the process such that the court is in the best position at the end of the day to be able to choose guilty or not guilty, liable or not liable. And because judicial inquiries are meant to be independent, the commissions set their own procedures, including rules of evidence. Limitations on inquiries are really those that we think about sometimes in administrative law. You need to stick to your mandate as a commission, otherwise face the prospect of judicial review. And spending all your time and money in judicial review really frustrates the mandate of public inquiries, and this has happened in many instances that we can look at. But the bottom line is that there is a notion of fairness to all parties, and that gives rise to things like providing notices of the possibility of an adverse finding against a party, which gives right to standing, to be able to attend at the inquiry, to be able to defend yourself and to participate in the examination. Pardon me. To participate in the examination of the matter at hand. The role of public inquiries, of course, is to deal with complex issues that often defy the easy fix. You're dealing with matters of pressing public concern, miscarriages of justice, Milgard being one such. Circumstances that are often tragic or outrageous. And public inquiries often depend upon, but not entirely, on public support for them. Although it is the public that foots the bill, so that presumably you don't have many inquiries that are not supported by the public. But as mentioned, there are frequently political repercussions as well, given the political undercurrent that often drives the calling of a public inquiry. Sometimes governments call inquiries to embarrass the previous government. That has often happened. But the bottom line is that public inquiries often deal with unpopular subjects that Parliament or legislators are unwilling or unable to risk their mandate by dealing straight up with. So a commission of inquiry, well, they can conduct an unbiased investigation and make independent findings and speak to the issue in a straightforward manner. At their core, public inquiries are called to address outrageous or terrible complicated situations that Parliament, the legislature, and existing legal and political institutions do not have the means or wherewithal to address. But for Indigenous people and for First Nations people, public inquiries have become truly a measure of last resort, a final resort from the blood feud, as often the legal and political options have long been exhausted, or, as we find increasingly, either non-existent or ignored by successive governments. For First Nations, or the role of public inquiries in relations to First Nations people, I submit, is entirely the same as for other Canadians, although public inquiries dealing with First Nations issues often have the additional complicating feature of the historical and cultural realities of this country. And I've already referred to the colonial history that imposed a legal regime over top of existing Indigenous laws and legal traditions. One of the first, the first judicial inquiry I was involved in was the inquiry at the Kingston Prison for Women. It was an inquiry that was headed up by Madam Justice Louise Arbour, and it was an inquiry into certain events at the Kingston Prison for Women of April 1995. I should tell you that I am a huge fan of Madam Justice Arbour, and if we have a moment at the end, I'll tell you a bit of a personal story about how I got to know her and how I got to know her even better, and why I have such a deep admiration for her. But suffice it to say that appearing before her was an absolute privilege and an honor. That case had to deal with female prisoners, primarily Indigenous female prisoners, who were incarcerated at the notorious Kingston Penitentiary. This is the first penitentiary in Canada, and it was built in 1835. And if you could imagine the medieval construction that might have occurred at that time, well, it hadn't changed much by 1994. And where the women were incarcerated was adjacent to some of the most dangerous criminalized men in the country. All that separated them through this whole between the two sections was some chicken wire. So these women had to endure a lot. The subhuman conditions that they were exposed to was eventually shown to the world, certainly to Canada, by CBC on a magazine called Fifth Estate. And the brutal conditions that these women endured, eventually compelling them to riot, which caused the emergency response team of the Kingston Penitentiary to move in on them. They were all men, by the way, dressed totally in riot gear. They cornered each of these women in their cells, holding them against the wall with their plexiglass shields, put them to the floor, cut away their clothes, handcuffed them to the floor, and left them there in that condition for hours, if not days. That horror eventually resulted in the inquiry being called, and the numerous recommendations that Madam Justice Arbour provided at the end of the day resulted ultimately in a healing lodge being built for Indigenous prisoners at Niganit, that is by Maple Creek, as well as the Edmonton Women's Prison. And the prison for women at Kingston was then closed down, as was the Kingston Penitentiary in its entirety. But part and parcel of the creation of the Healing Lodge was the development of culturally appropriate training and counseling methodologies, which were meant specifically to target recidivism among that population. In 2000, following a series of freezing deaths in and around Saskatoon, a case from 1990 emerged, and it was the case of a 17-year-old boy who had frozen to death in a field at the north end of the city with one shoe on, and rather curious marks about his face and wrists. His mother, Stella Bignell, had never given up looking for answers. I was able and had the privilege of working for her, and eventually to push for and get the Stone Child Inquiry, which was chaired by Mr. Justice Wright. We heard the term Starlight Tour coined as part and parcel of that practice, which was the practice of police services taking those that they deemed troublesome and dropping them off outside of the city, presumably for them to walk home and to walk it off. We found in that inquiry that this was actually a historical practice. However, when it is done in -30 weather, it becomes lethal, as it was in the case of that boy, Neil Stonechild. Over 100 recommendations, most of which have been implemented, came out of that public inquiry. And in the past decade, as they have been implemented, it did result in 2 steps forward. There is was a renewed relationship between First Nations people and the police service in this city, and perhaps in this province. And more recently, however, I submit that there has been slippage. There had been instances or thoughts about returning to carding, of racial profiling. And a major issue that causes many of us concern is the militarization of police services across Canada, as they have in the United States. In 2004 to 2007, the Ipperwash Inquiry was called in the province of Ontario. I was commissioned counsel in that matter, and it was an examination of the September 1995 killing of unarmed First Nations protester Dudley George by a police sniper following the takeover of the Ipperwash Provincial Park at the close of the park for the season by Indigenous protesters. The Stony Point people had been protesting the taking of their 5,000 acre reserve, their territories on the lakes of Lake Huron, ever since they had been forcibly removed from the land for the construction of the Ipperwash Army Base. The Ipperwash Army Base was constructed on their territory to train soldiers and to prosecute the Second World War. The promise that was made was that the land would be returned to the Indigenous people at the conclusion of the war. It hasn't been. One of the findings that was instrumental in that case, and I submit was a turning point, was the then Attorney General confirming that in a meeting in the Premier's dining room with police brass present, Premier Mike Harris was heard to say, "I want the fucking Indians out of the park," end quote. And while Premier Harris denied that, it was found that he did in fact say it. His former Attorney General confirmed it, as did others. And while that inquiry looked at the question of whether or not there was direct political interference in the operation of the police service in the killing of Dudley George, it did not find that there was direct political interference, but there was a finding that this led to an acceleration of the issue. And ultimately, it led to the incursion in the way that it did and the death of Dudley. The recommendations that followed out of that, many of which have been implemented, but not entirely, include the return of the Ipperwash Park, which incidentally did contain a burial ground of those people, and it did have a horseshoe pit that was constructed on the park, by the park on top of their graveyard. I guess that's why they were mad, and who could blame them? But that has not been completed yet, as the Army base itself has not yet been returned to the Stony Point people, nor has the decommissioning of the unexploded ordinances that completely contaminate that territory. That has not yet been completed yet. They estimate that the bill is some $50 million in the making and will take yet years to complete that work. But there have been positive changes in that, and there have been governmental changes in the province of Ontario that have been instrumental and educational in dealing with issues that arise with Indigenous people, or when Indigenous rights meet with other ambitions. Lastly, I was involved in the Truth and Reconciliation Commission, which ran from 2008 to 2015 as Commission Counsel. You will know that the mandate of that commission was to examine and to document the legacy of the residential school catastrophe in this country and to make recommendations as to how to deal with its aftermath. The commission was led by Justice Murray Sinclair, former lawyer, former judge, and former senator of the Senate of Canada, together with Marie Wilson and Chief Wilton Littlechild, QC. It was brought about by the settlement of the 7 class action lawsuits that I'd mentioned earlier that covered the entire country. It was brought by over 25,000 residential school survivors of the Indian residential school who were suing for the loss of culture and identity, as well as for the sexual, physical, and enormous emotional abuse that far too many of them had endured during the over 150 years that those were in operation. The settlement agreement, aside from providing for that compensation, had other various common components to it, including the independent assessment process where I know that Kathy Knox was instrumental in settling many of those as one of Canada's adjudicators. There was the apology that came out of that as well. The building of the National Center for Truth and Reconciliation, which is meant to house the records that were to be provided to the TRC by the church groups that ran the schools and by Canada, which incidentally they never did to their entirety. And we continue to insist that those records are important. As late as last week, we have been involved with Minister Miller on behalf of our client, to Kamloops Sekwepmek, who you will know that in May of last year made the stunning revelation, of course, which was known to that community and to Indigenous communities across the country, that there are many missing and unmarked graves, many missing Indigenous children from residential schools. There are many unmarked graves right across this country at residential schools, and we need that information in order to begin the sacred work of identifying who those missing children are, identifying who are in those graves, and ultimately to repatriate them, because their families deserve to have that closure and they deserve to have that dignity. The TRC traveled for over 6 years across the country. We listened to more than 7,000 survivors. I learned what it means to listen and to hear and to actually see the kind of pain and anguish and fear that has driven many of our communities, that is alive and well in many of our communities, that continues to haunt so many within our communities. And it's no wonder that the social issues in our communities and amongst our folks are so difficult to overcome. If I hear somebody say, just get over it one more time, I mean, I'm probably going to blow a gasket. But I don't want to say that we only heard incredible stories of pain and sadness, but we also heard stories of amazing endurance, of outstanding love, of incredible survival stories. And I know that those stories are imbued within our communities as well as the sad ones. I know that powers the resilience of so many of us. I know that it does for me, and I know that it does for many of you out there, that we take the strength that these survivors have shown us, and we build upon that to say that we can be advocates and we can make the kinds of changes that our grandchildren deserve in this society. We can make the kinds of changes as people of goodwill and of common intention that our grandchildren deserve, that we all deserve, that we all want. So I'm not sure where I was going to end. I did have some other comments. I do know that there might be some questions at the end, but I guess I would wrap this up by saying that I am extremely grateful to all of those who have did the difficult work of advocating for marginalized people for so long. People like Halyk, people like Kathy Knox. And there's others of you that are not named here, but who we continue to look up to and who we continue to follow in your footsteps. And I hope that the few words that I have to offer at least contain something that might be useful to you. So I think before I stumble any further, I will end my remarks there. I will say thank you again for the kind invite, and to Elise and to Brent, thank you very much for the invitation, to Cy and to Kathy, thank you.
John, Brent, did you want to just wrap
If I
up
may?
the?
If I may, sure. Just before a reference to Don's remarks, I wanted to extend my thanks to Shannon Durand, who's been the setup person for us for a very long time with respect to the Speakers Committee, and who has sadly left us, but we've been joined now, and Claire Underhill has taken over those responsibilities. And I just wanted to thank Claire for doing a fine job setting this up with no glitches and a very effective and widely observed session. For myself, Don, as usual, you bring not only your insights, but sort of the power of your commitment. And I think any fair-minded person would be inspired by the remarks today, both the challenges that have faced social justice warriors, but also the ways in which some of those opportunities have opened up and hopefully will open up in the future to produce a more just society for us. So I wanted to extend my own personal thanks. And if Cy is able to click on and unmute, I wanted to invite Cy Halyk to offer a word if he would like to do that. Cy, are you nearby? Are you still masquerading as Catherine Knox?
Hello, Senator, again. I just think that this was a exceptional session, and Don, you never ever disappoint me. You've worked with me, and we've worked together on many issues, and it's great. The job that you did today is beyond belief, actually, and I hope it gets repeated. This lecture somehow gets circulated around so that all the people around can hear and understand the importance of what you've done and continue to do. And thank you, Brent, for all the work that you put into it. I know that I owe you a cup of coffee, and one of the days we'll get it. And thanks to the support people throughout. Thank you very much.
Thanks, Cy. And sort of undoubtedly echoing his words, I think on behalf of all of us who have sat in on the lecture and those at the law school, and the good news is that I hope you're comfortable with this, Don. This has been captured and will be posted on our website for others to watch if they weren't able to today. So in conclusion, thanks again, Mr. Worme, for an outstanding advocacy lecture. Thanks to Mr. Halyk for his support and generosity in making this lecture series possible and bringing distinguished advocates to the law school and to the broader community. And thank you all for joining and listening in, and we'll be back in a week with the next one for you to enjoy. Thanks again, and all the best for the coming week. Take care.